Hello, and welcome to this webcast from the Anti-Fraud Collaboration. In the past, the Anti-Fraud Collaboration has hosted webcasts on how to deter and detect fraud or suspicious activity. Today, we're going to shift our focus to what a company, its board, and its executives should consider when determining when to report fraud to the Securities and Exchange Commission. The Anti-Fraud Collaboration represents the collective efforts of the Center for Audit Quality, Financial Executives International, the National Association of Corporate Directors, and the Institute of Internal Auditors. These organizations all are actively engaged in efforts to promote the integrity of financial reporting. I'm Cindy Fornelli, Executive Director of the Center for Audit Quality, and I'm pleased to moderate our discussion today with a terrific panel of experts. But before we get started, I have a few housekeeping matters. As noted on slide 2, I am pleased to announce that this webcast qualifies for 1.5 CPE credits and 1 NACD skill-specific credit, which can be applied to one of the 2 fellow programs offered by the NACD. For those of you who have registered for CPE or NACD credit, you must confirm your attendance throughout this webcast by clicking the participation pop-up markers. When you see the pop-up marker, simply click the green arrow. Also keep in mind that in order to obtain CPE or NACD credit for today's event, you must respond to at least 75% of the participation pop-up markers. If you did not register for CPE or NACD credit, you can ignore the pop-up marker. They will disappear within 1 minute if they are not clicked. Finally, please note that there will be an evaluation of this webcast that you can participate in after, and we would be very grateful for your feedback. Now let's move on to today's program. Slide 3 sets out our goals for this webcast, which are the following: to provide insights into when to self-report fraud or suspected fraud to the SEC, to discuss how companies can benefit from participating in the SEC's cooperation program, to set forth the factors to consider before approaching the SEC, and to provide a clearer understanding of what is considered cooperation by the regulator. As I mentioned, we have a terrific panel of experts to help us meet these objectives. So turning to slide 4, I'll give you a quick introduction of each panelist. In alphabetical order, I'll start with Kara Brockmeyer. Kara is the Chief of the Foreign Corrupt Practices Act unit of the SEC's Enforcement Division. And in that role, she oversees nationwide investigations into violations of the anti-bribery and accounting provisions of the federal securities law. Thank you for joining us today, Kara.
I'm delighted to be here, Cindy.
Also with us is Rodney Chase. Rodney was elected to Tesoro's Board of Directors in 2006 and serves on its Audit and Governance committees. He's also served as a director of Hess Corporation since 2013 and is a member of its Audit and Governance committees as well. Rodney, thanks for joining us.
Thanks for inviting me.
Our third panelist is Timothy Headley. Tim is the partner in KPMG's forensic practice, and in that role, he serves as the lead of the firm's fraud risk management services, which assists companies with the deterrence, detection, and response to fraud and misconduct. He's also the co-author of the recently published book, The Era of Regulatory Enforcement, a comprehensive guide for raising the bar to manage risk. Tim, welcome.
Thank you. Nice to be here.
And last but certainly by no means least is Fiona Phillip, who is a partner at the law firm Sidley Austin. Before joining Sidley, Fiona worked for the SEC in the Division of Enforcement and was part of the original Financial Fraud Task Force. She also served as counsel to 2 SEC chair. Fiona now represents clients in a wide range of government and regulatory investigations, and we're very pleased to have you on our panel.
Thanks for having me, Cindy.
So now let's turn to slide 5 and dive into the substance of our program. I want to start with a bit of context. In 2001, the SEC issued the Seaboard Report, which provides the mechanism for recognizing cooperation by companies. And in 2010, the Division of Enforcement adopted a cooperation initiative that provides tools and incentives for individuals. Kara is going to give us an overview of the program, so we'll get to hear from her for a couple of slides worth. But before I ask you my first question, Kara, I believe you have something you need to share with us.
Yes, the views that I'm going to express today are my views alone and don't necessarily represent the views of other members of the staff of the Commission or the commissioners themselves.
So, having gotten that out of the way, give us a broad overview of the cooperation program and share with us some of the agreements that you see and what kind of cases you see and any trends.
Sure. So beginning in 2010, we formalized the program to give us tools that the criminal authorities had been using for a number of years that the SEC didn't. So now we can enter into cooperation agreements with individuals. We can use deferred prosecution agreements or DPAs and non-prosecution agreements or NPAs. The difference between the two is typically there will be a period of time for a DPA or an NPA. It's often 3 years during which we agree that we will defer prosecution or will not prosecute as long as the company complies with certain undertakings. Typically will be remedial efforts and also the obligation that they're not going to have any additional problems. So this gives us an opportunity to recognize cooperation a little bit more formally than we were able to do previously.
And that's a deferred compensation.
A deferred prosecution agreement, yes.
And what's a non-prosecution agreement?
So a non-prosecution agreement is where we would recognize that the company had a violation and we would set forth the facts of the violation, but also explain that usually given the limited nature and the typically the quick response time and ability to correct the issue, that we are saying that the company had a violation and they'll typically have to pay back any profit that they earned as a result of that violation, but we will not bring formal charges against them.
So moving on now to slide 6, we've got some considerations for cooperation by entities. So can you talk to us a little bit about when the SEC might consider that an entity has provided, or an individual has provided extraordinary cooperation with the SEC?
Sure. So first of all, as you can see on the slide, the Seaboard report actually sets out 4 pillars or factors that we consider that often sort of get lumped together as cooperation. So one is self-reporting. Did the company report to us before we learned of the problem through a whistleblower or through a report or a referral from another agency? The other is self-policing, which typically has to do with how well the company had good internal controls or good compliance programs in place. So were they doing a good job of policing themselves to catch problems before they grew? Then cooperation, which is typically considered the cooperation during the investigation. So did they take voluntary steps that helped us streamline and expedite the investigation, that enabled us to learn the facts and also learn the company's view of what actually happened at the company, and then remediation, which is how they fix the problem. So the types of things that we often talk about with respect to cooperation and getting cooperation credit are the type of voluntary assistance that the company can provide. For example, if it's doing an internal investigation, if the company provides downloads of the information that it learned, if it provides voluntary collections of hot documents or binders of particularly relevant information. Does it provide access to witnesses that might be overseas or otherwise more difficult for us to get access to through our own mechanisms like subpoenas? Does it help us with, for example, translating documents that are in a foreign language that can speed up our investigation so we don't have to hire translators ourselves? Things like that.
Cindy, just listening to Kara talking about this, I think we're going to dive more deeply into many of these aspects I know today, but I think it's important to note today that when companies are thinking about this whole process, they don't have to be able to cooperate with every step that Kara has gone through. In fact, there may be specific circumstances which make that impossible. But a pattern of cooperation in a number of these areas, I think, as we're going to find today, they do amount to a substantial commitment by the companies to work with the regulator.
So Fiona, Kara shared with us what is cooperation.
Right.
Are there things that our viewers may think of as cooperation that's not, that's just normal course?
Yeah, good question. So one of the things that Kara noted is that it must be a voluntary action, right? That oftentimes you hear clients say, but we brought in a number of witnesses for testimony, or we produced millions of pages of documents. If those documents and those individuals are under subpoena, the company has an obligation, the individual has an obligation to testify. That is not cooperation because it's not a voluntary action. So I think a lot of people, unsophisticated companies and unsophisticated individuals believe that just complying with the subpoena is enough, and frankly, it's not.
Interesting. Okay.
I agree with that. A lot of my clients, I just think if they go along with the subpoena direct request from the SEC, they're cooperating fully. They're not cooperating, but I don't think it rises to that level of voluntary cooperation and going that to the next level.
Right, and I think that's actually an important point that you raised, which is it's not just subpoenas, it's subpoenas to public companies. But if, for example, you are an independent auditor, or you are a regulated entity, a broker-dealer, or an investment advisor, we don't even need to send subpoenas. We have other mechanisms to get the information short of a subpoena that still would not be considered voluntary or would earn you cooperation credit.
Right.
So moving on now to slide 7. As we've talked about this tee-up and this introduction, we basically we're talking about entities or the company, but also the SEC can give credit to an individual who is cooperating as well. So describe the general considerations used by the SEC in addressing cooperation by a person.
Sure. So this is actually something that is, the Seaboard factors have been around since 2001, but the factors for formally recognizing cooperation by an individual are relatively new. They were part of the Enforcement Cooperation Initiative in 2010. So as you can see on this slide, there are 4 general considerations that we look at. The first one is what degree of assistance can the individual provide? So for example, if you are representing an individual who is more peripheral, there's a more limited set of information. If you're representing someone who is a direct witness to the events or can explain documents or explain how a transaction that may be a fraudulent transaction worked, then you're more likely to be able to provide significant assistance. The importance of the underlying matter often has to do with how big a case is it. Is it a minor accounting issue that really was more negligence than anything else? Is it an intentional fraud case? The interest in holding the individual accountable often goes sort of hand in hand with the degree of assistance. The more likely you are to be at the locus of the conduct, the more assistance you can provide in explaining the conduct. So that's where we're going to be looking at the difference between, is it just the individual can enter into a cooperation agreement where we're not going to take any further action, they're just going to agree to cooperate, versus it's someone who has to be held accountable because they did engage in wrongdoing, they violated the securities laws, but if they cooperate, if they express remorse, they can have significant upside when it comes to figuring out what the resolution should be, whether it's a DPA or an NPA, or even it's just a reduction in the penalty or the timeout, the O&D bar or the auditor bar that we would be seeking.
And Fiona and Tim, you might have some experience as this as well. Thoughts on clients that you've represented as individuals?
Yeah, so the rub there as outside counsel and counsel representing individuals is really how much of a benefit is the individual going to get if they come forward with the information. As Kara said, the more pertinent information that you have for the SEC, if you know where all the dead bodies are buried,
Proverbially speaking.
then, right, the closer you are to the actual wrongdoing. And you have to weigh as that individual, not only did I violate the federal securities laws civilly, but where's the DOJ going to become involved, or the U.S. Attorney's Office going to come involved? And so when as an individual you're thinking about, do I come forward with the information, it's a very careful balance about, do you go to the SEC or the DOJ first, and how do you maneuver around a civil agency and a criminal agency? So it's a tough balancing act for individuals. But again, the key is that you have to help the agencies figure out the wrongdoing in terms of letting them know who the relevant individuals are, key documents to find, where to find them, names of, if it's an FCPA case, who the foreign officials are that are involved, and how exactly the fraud, whether it's a bribery case or an accounting fraud case, helping the agency figure out exactly how it was done. And that really is the key to cooperation for individuals.
I think that's a good point, which is just simply responding and testifying truthfully when you're under subpoena is not enough to get you cooperation credit.
And the goal here behind these programs, correct me if I'm wrong, is to help the SEC maximize its resources, right? These are investigations that you're probably going to do anyway,
Yes.
and you will expend the resources to find these things these types of issues that Fiona just outlined for us. But by having somebody come forward and sharing that information ahead of time saves you the resources for having to go do it yourself, and at the same time then allows you to give that individual or that entity credit.
Yes, that's true.
I mean, in a nutshell, right?
Yes, so it can help us walk through the documents. It can streamline our investigation because they may be able to tell us of the 30 people that we're considering potentially taking testimony from, these are the 5 or the 10 that are most likely to have information. They may be able to help us, for example, in the case of an individual, describe for us the documents that are going to be most relevant so that we can direct the company to those and make sure that we're getting that production. The other point that I want to make sure is not lost is that, as Rodney said, it's not an either or. It's not 100% in or 100% out. If you don't come forward and self-report, if we show up at your door with a subpoena, it doesn't mean that you still can't get cooperation credit if you're an individual. If you want to come forward, you can cooperate in that moment and start cooperating from that point on. And in fact, we had a case last year where that instance occurred. It's the same thing with a company. You can choose to cooperate on some. You don't have to do absolutely everything. We do partial credit. It's not necessarily 100%. But the more you come in with a cooperative attitude, I think it's not just the tangibles of what is going to buy me at the end, what am I going to see on the resolution. I think it also can help streamline the case. It can help give the company a sense, if it's the company cooperating, of what the regulator is thinking about, so they may have a better sense of where the investigation is likely to go. So are they looking at a case, for example, in this area where we think that there is intentional misconduct, so we're looking at CANTOR-based fraud charges. Do we think that do we agree with them that we're just seeing it more as an accounting case, books and records, internal controls? That can also help a company decide at what point do I want to approach the government and say, I think I'm ready to settle. So you could cut a year off the investigation simply by kind of knowing those types of, when you have a meeting of the minds.
So Fiona, you mentioned the Department of Justice. We did get a question asking about sentencing guidelines. This, what we're really talking about today, is the SEC's cooperation program. But does the Department of Justice have something similar?
To the SEC's cooperation program. So particularly earlier this year, the DOJ, unveiled its FCPA pilot program, in which it spelled out what companies can do in order to receive cooperation. And unlike the SEC, and I think this is someplace where a lot of people are critical of the SEC, is that we believe that it's not so transparent where you get credit and where you don't get credit. And I know, Kara, you'll speak to that later. But the DOJ is very clear that you can receive a reduction in the fine or a reduction in a penalty or fine if you do certain things, right? And so with the April 2015 launch of the FCPA pilot program, the DOJ talked about translation of documents, one of the items that you just talked about, that bringing forth information on culpable individuals, right, which was a piggyback to the Yates memo, and very much all the things that you can do to get a reduction in the penalty. For example, it said in that memo that if you did not bring the matter to the DOJ, but then the investigation started and you started to cooperate later, you can get a 25% reduction in the fine. That memo also said if you self-disclosed, if you remediated, if you sort of did all the things and checked all the right boxes, then it's possible to get a 50% reduction in the fine, and possibly, right, a non-prosecution agreement and no monitor, which is huge for companies. And those things are spelled out by the DOJ, which I think some people would say the SEC doesn't spell it out as clearly as the DOJ does.
Yeah, so we certainly have been trying over the past year or two to become clearer. I think we're going to talk about some of the cases where we have gone out of our way to to sort of spell out those same factors that we looked at that gave companies cooperation credit. It's true that we don't have something like the penalty guidelines. I think as we're going to talk about later, you can see on the SEC side where you're getting credit, because it's typically going to be on the penalty or on the type of resolution. So we can do a civil injunctive action, we can do a cease and desist proceeding. If people prefer a cease and desist proceeding, that's one thing that we can offer. The penalty, particularly if we're doing it in federal court, can always be equal to the amount of the company's ill-gotten gains, so their disgorgement amount. So anytime you see an SEC resolution where there's a disgorgement amount and a penalty amount that is less than that disgorgement amount, that gives you some sense of what the, what the potential benefit was to the company. But we don't have the same type of thing now that the DOJ has with the pilot program.
I think some of that is not well understood by people. That math you're talking about.
Yes.
The disgorgement and the penalty be the same. If one's less than the other, there was probably some benefit to it. I don't think that's well understood by many of my clients.
And that's, it's interesting. I think at the SEC, we tend to think that everybody should know about it because it's written into the statute the way that we calculate the penalty. But yes, as I've been doing this job now for a number of years and going out and talking to a lot of audiences, I hear that people say, I don't see it. And I'm like, well, if it's disgorgement of $3 million and a $375,000 fine, I can tell you right there, it's about 10% of what it could have been on the penalty side.
But the press release doesn't say that. And that's what they're looking at. And
Yes.
They still see a lot of penalty and a lot of disgorgement. And I wasn't sure how they got the math came together.
And I think that's a fair point, and that's why we have both Andrew Seresny, my boss, and certainly I in the FCPA space over the past year and a half, when we're going out and speaking engagements, have tried to be much clearer. We've tried to be clear in the press releases as well. We've also tried to make it clear, for example, in my area in FCPA, where if DOJ is doing a parallel criminal action and has a very large criminal fine, we typically won't have a civil penalty, and we've tried to make it clear in the papers we're not assessing that because of what DOJ is doing. But yes, there's clearly still more publicizing work to be done.
So Kara, you mentioned your boss. Come January 20th, you're going to have a new big boss, right? There's a new administration coming in. So talk to us a little bit about how that might impact the investigations that are currently ongoing and even the cooperation program.
Well, certainly, every time a new chair comes in with new commissioners, they set new priorities because they are the client. But I've been at the SEC for 16 and a half years, so I've seen quite a number of chairs from both parties. And the vast majority of the work in our investigations goes on regardless of who is, who is the chair. So I anticipate that, the investigations that are ongoing are going to keep going on.
So now I want to move us on to slide 8. And Rodney, I want to get you in on this because as a company director, you've been on the other side of the table for an SEC investigation.
Unfortunately true.
Yes. What are some of the key points that you would advise a board to think through before stepping forward and cooperating with the SEC?
And I think these circumstances will vary depending on what companies find themselves suddenly confronted with. But there are some general points. I think that one thing that must be clear right at the start is at the very early stage when a board of directors of a company finds out that they've got a problem, they will know relatively little about the dimensions of that. They'll be concerned that it might go much further. They'll be concerned that they need to have some time to do their own investigations. They're not sure who to trust at this stage. They'll be being advised, certainly by in-house colleagues, that they should keep things relatively quiet until they know a lot more. And I think that at that stage, the most important advice I'd give a board of directors is to be realistic and assume that this, if it's an investigation that has reached the SEC and has got that degree of seriousness, it's going to be time-consuming, it's going to be stressful, it's going to be problematic. And most importantly, for independent directors who, let's face it, are part-time in the way they do their work, this is likely to metamorphose into something that's pretty close to full-time for some of them. So I would say a board of directors, especially if they have discovered the issue, if it's come to their attention either from their own oversight or auditing activities or from a whistleblower that's come to the board, if they have the time to reflect on it and begin to do some serious planning work, they should take control of the investigation as independent board members. This is not something that should be left too long with management. There should be no assumption that this is just another routine part of delegated responsibility that the CEO and his or her team will take care of. This is an issue which needs to move to the desks of the independent board members, and they need to begin to think about how they're going to organize themselves. That's a big job for people who are not full-time organized in their day-to-day job as directors of a company. They probably need to appoint an independent committee of themselves to run that investigation. It may be the audit committee, it may be some combination of different members of the board, depending on the skills that are required. And I think they very quickly need to start thinking, where will I turn to for independent advice? Again, I think there is a role for the general counsel, for the senior executives in that team to contribute to the investigation, but above all, it must be perceived to be and really be an independent study, an independent investigation. So you're going to have to find independent legal advice. Almost certainly, if it's a matter that's come to the SEC, it's going to require independent financial advice, audit advice, maybe other forensic investigative skills brought to the table. And all in all, at this stage, I would say the board of directors really needs to prepare for something which is closer to a full-time piece of work than something which is more akin to their usual duties. It's not going to be welcome. It's not going to be enjoyable. I can tell you that from my own experience. But I would urge directors to begin thinking that way early on.
I probably would have changed one word, except I agree with everything you said. It was the notion of run the investigation. I think oversee might be a better word,
I understand.
because I've seen audit committees attempt to do the investigation themselves,
Yeah, of course.
start conducting inquiries and what have you. But everything you said, I thought made perfect sense. It's just an oversight capacity is what they should be in, and staying attuned to what's going on. But some do have a tendency to start running the investigation itself and directing investigative steps, and I don't think that's necessarily appropriate because they're not investigative professionals in some sense.
But you raise a good point, Tim. I think that people who haven't been through this before will probably make some stumbles. They'll probably start doing some things which they can't continue doing. But it will become crystal clear early on that the capability to actually handle the investigation must be supported by professionals who know what they're doing, and whether those professionals are lawyers, whether they are administrators, whether they are financial advisors and audit advisors. You're quite right. It's an oversight job, but it's an oversight job which has got rather more hands-on than the everyday job of an independent director.
Yes, I agree with that.
One of the issues that I've seen boards trip up on is sort of how information is controlled about an investigation. So boards being active in an investigation, I think it's critical to have a special litigation committee or a special investigation committee, because when investigations start to unfold, you don't know which of your executives or even other board members, for that matter, may end up testifying in the investigation or providing documents in an investigation. And sometimes I see at the beginning of investigations, because the company is not thinking down the road strategically, there's information that is shared with board members, with members of management, that later has implications for the investigation. And so I do think having independent directors form a special litigation committee or a special investigation committee is the best practice in this area.
So Fiona makes a very important point here. Now I'm going to dip into the experiences that I was involved in. It wasn't, I should say quickly, either of the companies whose boards I sit on today. But it was a number of years ago, and the process started like this. We had an internal whistleblower who brought to the attention of the audit committee chairman an issue that had arisen in a small overseas subsidiary of the company. It subsequently turned out to be a books and records fraud. It was people misreading the tone from the top, and they took those signals, which were somewhat distant, to encourage them to do things which they clearly should never have done. I mention that because the way the investigation proceeded it grew substantially, and as the board decided to cooperate with the SEC, decided to self-report, decided to work out through its lawyers with the SEC a program for the investigation, it became clear that if it was in fact emanating from a misreading of the tone from the top of the company, it wouldn't be reasonable to assume that it simply applied to one small affiliate of that company. And so as a board, we agreed with the SEC a much wider investigation. At that point, not only did the substance of the inquiry grow, but the way that it was handled had to grow. It became multicultural, it became multilingual, it became multi-jurisdictional, and a number of the points which Karen and Tim were talking about a little earlier today came into full focus. And I would say from that experience, the key issue, the key problem that I look back on, that we as an independent committee struggled with, was whether to isolate senior management or whether to keep them involved because they would help us not only run the company day to day, but help us find out in the investigative process much more quickly and much more reliably what we needed to understand and what might actually need to be remediated. And I would say that over the subsequent 3 or 4 years, I was pleased that we kept those senior management involved, even though the SEC chose down the road to turn their investigations on them as individuals as well as on the company. And I know that some people say, well, the board should take early action to bring in new management, take some tough decisions early on. And I would say that one of the biggest challenges that we as directors have in those circumstances is how to best look after the interests of shareholders in ensuring the company is actually still run, that its customers are still served, that its partners are still taken care of, et cetera, whilst on the other hand not cutting across the legitimacy of the investigative process. It's a tough one for boards of directors, certainly based on my experience.
I think it's fair to say that it's also something that we look at the SEC, because there have certainly been times where, for example, with investigations that I've been involved in, where we've gone to the company and said, we need you to wall off these executives that you have not walled off because we have now learned that they have factual knowledge. It may be that we're looking at them as someone who has potential liability. It could simply be that they're fact witnesses for us, and what we want from testimony is their own independent recollection, not colored by what the investigation may have learned, and that can be very difficult. I think the easiest situation for a company to cooperate, in my experience, is where the conduct involves former members of senior management, so that the board is really dealing with a clean slate and new management, and it can be much easier for the company to agree to cooperate fully under those circumstances, because they don't have that same divided loyalty that I think is there when you have, even with an independent board, you have senior managers that are there and that were there throughout the troublesome conduct, and those are the cases that I think present the most difficulties for the companies too.
But it is really a balancing act, right? Because as you mentioned, you have to do what's in the best interest for shareholders, and you want to cooperate with the SEC and DOJ investigations. But there are times when a company will need to figure out, how do I best keep my senior managers and also cooperate with the SEC investigation. The scenario you talked about, Kara, is sort of the best case scenario, right? And the easiest one to deal with. But I think each SEC investigation is different. It's a facts and circumstances analysis, and I think you have to figure out, sometimes the staff may look at a particular executive, but, the company stands fully behind that executive because they know the nature, the character, right, the core of that individual. And as outside counsel, it's up to us to help the company and the board navigate, and the government, for that matter, navigate sort of those very difficult analyses that needs to take place.
And I think that raises a good point, that one of the key things I think for cooperation that works best when a company decides they want to cooperate is establishing early on a a trust between the company, its outside counsel, and the government, and full and frank communication. Because if you have that type of situation, those are exactly the types of situations where you want to talk through those issues. Because there may be solutions. For example, walling off an executive from the investigation, walling off an executive from a particular part of the business where the investigation is going on, but allowing the executive to continue. It may be that if you raise those issues with the government, we're able to streamline or expedite the part of the investigation that touches on an executive that for the company may be important either long-term because they believe in the executive. Sometimes it's a short-term. For example, if you have a company that's under investigation that's considering a merger and acquisition, some other type of business acquisition where they really need the executive there for a period of time. And I think if you have developed a relationship of trust, which I know sounds odd when you're under investigation, but you can talk through those issues because sometimes what the company thinks may be an issue isn't. And sometimes they may not be thinking of things that from our perspective, based on what we know or have learned in the investigation, they may not think is an issue that we believe is really going to be. And it's incumbent on us to raise that so the company knows that we view it as an issue.
So Kara, what happens, because it sounds like having outside counsel or these outside advisors, Rodney, that you discussed was probably going to be the primary conduit with the SEC. If you don't feel as though outside counsel is being cooperative, do you let the company know? Do you let the executives know or the board of directors know?
Yes, certainly that's best practice, and I have definitely done it. I think honestly, it's not a good sign if you hear from outside counsel that the SEC has requested that the general counsel, or even worse, and that independent members of the board come to the next meeting, because it typically means that things aren't going well. But I think it's just sort of a practice pointer. I think that I think it's a good thing for a company to think about, even if they don't think that there are problems, occasionally having their in-house lawyers go to significant meetings. There may be meetings where you don't want your in-house counsel there, but just to go and see. I think in-house counsel can learn a lot about how an investigation is going on and what the relationship is between the staff and the company, and does it seem like there's a good relationship there where you're trying to get at the facts and trying to figure out, at least can you agree on the facts? You may disagree on how the law applies to those facts. By going to the meetings, some of the key meetings, particularly if the government is saying we're ready now to do some type of reverse proffer or discussion about how we see the facts. I think that's something that I don't actually see as many companies taking advantage of that as might. Regulated entities, I think, tend to be a little bit better about that.
That is very true, but I think there's a reason for that, right? Because outside counsel provides the buffer between the government and the investigation and the company or the board. And you don't want your client sitting there being asked directly about certain issues when you haven't had time to either prep them on the issue, or the government has some document that you don't know about, and suddenly there's the general counsel. There may be a memo with the general counsel's name on it that you know nothing about, and that's the government's opportunity to suddenly spring it on the general counsel because he's in the room.
And see, that's a very good point, because I would suggest then that you don't bring the general counsel, and that the general counsel should be walled off, because if their name is showing up on a memo, they shouldn't even be involved in the investigation. Find somebody lower down who's new, who can just report back.
There's one other issue, though, sometimes, even with outside counsel, that sometimes they're thinking more as advocates for the company and not performing truly an independent investigation. And I see that happen more times than it should. They're just not thinking independently, arm's length from this thing, but they've been the long-term counsel for this organization. They may be outside and in some way thought about being as independent, but they just may have always been working as advocates. Sometimes internal counsel does the same thing, but that's essentially what they've been hired for.
I think it makes a very good point. And in the examples that are part of my experience, we got to a stage several years in when we brought in not only another law firm, another independent law firm, but another accounting firm, because we felt we needed independent advice, independent of the investigation process, in order to help the board make a decision about, have we reached a point in time at which we should respond to possibilities of resolution. And that's always a very difficult time. And at that stage, when tension is high and there's potentially a lot of money at stake, the need for objective, really independent advice feels really crucial, and one's searching for it then.
Companies will start the initial triage of the problem with their existing counsel, and eventually at some point have to make the decision. Like, I think the point you're making is that this is not the right law firm for this particular issue. We have to go someplace else, but oftentimes they'll start the triage with that and then serious, or have them start with responding to a subpoena. And then after a certain point, you realize we need another law firm to step in, make sure they're more independent of the process.
But I think what this conversation brings out is the fact that in investigations you have to be fluid, right? And just because you start with a certain investigation plan, that doesn't mean that's the investigation plan throughout the entirety of the investigation. The example that you had where it was just one small subsidiary that had the issue, and later you figured out there were other areas that we needed to look into as well. I think, you know, you have to be nimble, you have to be, I don't want to say creative, is not the right word, but you have to be nimble. And I think at certain, flexible, and at certain points in investigations, you have to take an assessment of where you are and what else do you need to do, because the plan that you had on day 1 is not necessarily the plan that you need on day 10 or day 25 or year 1 or year 2 for that matter.
Right, I think those are all good points, and I think Tim raised a very valid point, which is that there is a place for the company's usual outside counsel to act as their advocate, and that's often who we'll see at the point at which we're potentially negotiating a resolution. But that's usually not who we like to see doing the internal investigation, because they're not going to be able to bring that same independent view, because their loyalties often are to existing management. And I think it can be very difficult when a company is facing, for example, in this space, it would be a restatement. So that may take away some of the issues of do I self-report or not, because at the point at which you have to make a restatement, that's a pretty big announcement to the SEC that you have a problem. Guaranteed investigation. But that's a point where that's a good time, if it's material and you think that there are issues, to bring in somebody independent to take a look at it, because at that point, from my perspective, what I want to see for an internal investigation is that what they're representing the board, but the board standing in the shoes of the shareholders. And are they looking to, however the chips may fall, to find the facts so that they're able to represent the best interests of the shareholders?
So this has been a very interesting and fascinating thread, and I think we'll pick some of this up a bit more later in the broadcast. But I do want to move us on to slide number 9 and talk a little bit, and Kara, I'm going to start with you, about what are some of the concrete benefits that a company can expect? Because we've talked in generalities that there's going to be a benefit. Give us some examples, and I know on slide 9 we have some of these, but give us some particulars about what a company might expect.
Okay, so if a company is cooperating, whether or not they've self-reported, but they're cooperating during the investigation, and we're at the point where, let's say, for example, we all agree there's been a restatement, there is some type of, at least books and records and internal controls, and let's say that the government says that we have sufficient evidence that we're also going to have fraud charges, at least against some individuals. The things that would be on the tables, for example, the type of resolution. Do we do a civil injunctive action in federal court, or do we do a cease and desist proceeding, which would be an order issued administratively by the commission? There are pros and cons to both. We usually have those back and forth discussions, but some companies have a much greater preference for one versus another. How do we view the company's remedial steps? Do we think the company needs a corporate monitor going forward? Or do we think that the company, through its cooperation and remediation, has shown that they understand they had a problem, they got on the problem quickly, and they fixed it? When we're coming to the type of resolution for companies, is it going to be that we're going to insist on, for example, 10B charges, which are the intentional fraud? Would we consider that maybe, for the company, it might be appropriate to do non-scienter-based fraud charges, for example? Or if we have good evidence that executives circumvented what was otherwise a pretty good internal control system, do we say that we're going to put the fraud charges on the individuals? That would be unusual to not do the company, but possible. Where you're really going to see the potential for the reward is, as we've talked about, on the penalty side, where we have the ability, we have a range of penalties under our statutory authority that we can assess, and that's where we're really going to be talking about what is the benefit, because the purpose of the penalty is obviously to punish and further deter the conduct. And so the more the company has been able to show us that they cooperate, that they understand they have an issue, and that they got on top of it, the less we're going to feel they need to be punished or deterred in the future. So it can be a cease and desist order versus an injunctive action. For individuals that are cooperating, it's the potential for either no or a more limited, for example, officer and director bar. So instead of seeking one that's permanent, maybe a 5-year, if the individual is cooperating, reduce monetary penalties. In small cases, so more unlikely in a restatement case, but in smaller cases, we could decide not to bring any enforcement action at all, or we could do what we've already talked about, which are DPAs or NPAs, and we have a couple of examples of those to go through.
Yeah, so if we move on to slide 10, we've actually got some real live examples of companies that participated in the cooperation program and had reduced penalties as a result of that.
So these all happen to be FCPA cases, but in addition to the bribery, all of them also had books and records and internal control, so accounting violations. About a year ago, in November of 2015, Andrew Seresny announced that one incentive for self-reporting was that we were just going to make it clear that in order to be considered for a DPA or an NPA, the company had to self-report, meaning that you had to come to us before we learned of it or were likely to learn of it from a whistleblower, from an article in the New York Times the next day, from a restatement that you would have to make. So 2 companies in June of this year, Akamai and Nortec, received NPAs with no penalties. So all they paid was the disgorgement. As I said, these were FCPA cases, so there were bribes being paid at their Chinese subsidiaries in order to obtain business. So there was an illicit benefit that they had to disgorge, of course, to put them back in the position where they were. But because of their extraordinary cooperation, the fact that they self-reported, they did very expedited internal investigations. They provided access to all of that information and witness downloads. They helped us get access to witnesses, translate documents, all of the things that we've already talked about for cooperation. And also because it was relatively limited conduct and a relatively small amount. I think there was $700,000, somewhere in the $1 million range. It wasn't a $100 million case that we were talking about, that they were appropriate candidates for NPAs. SAP is a slightly different and kind of more interesting case, which was SAP had a problem in one of its, I think, Central or South American subsidiaries. And they provided significant assistance to us in being able to bring charges against the individual, their employee, or by this time now a former employee who had engaged in the wrongdoing. And so that was one way where they were able to, for them, they needed to clean house. That was not conduct that they approved of. But because they were able to provide very significant cooperation for us, they ended up paying disgorgement and interest, and they had a C&D, a cease and desist proceeding, as opposed to some type of injunctive action.
So I'm going to turn it over, Tim, to you, and then Fiona, and this answers one of the questions that we've received. I think there's some skepticism in some quarters about moving forward, and particularly maybe in cases that don't result in a restatement. I think there are some quarters that feel as though self-reporting doesn't get you anything, that the company may not have been caught, if you will. So how would you advise clients about self-reporting? How do you address that skepticism, that why would we come forward and tell on ourselves, if you will?
I'm going to let Fiona go first.
Well, let me talk about some of the reasons why there's that skepticism. I alluded to it earlier, where people don't see the benefits on the SEC side as clearly as they do the DOJ side. Hopefully some of those cases, people can see that the SEC laid out very clearly all of the cooperation steps that were taken. But when you self-disclose and an investigation is launched, right, you have the cloud of an investigation hanging over the company, right? That the employees, there's uncertainty for the employees. There's a drag on the share price if the investigation is disclosed. And, analysts are asking about the investigation rather than about the business of the company. There's also the cost of the investigation, right? So whether it's an FCPA investigation or accounting fraud investigation, investigations and representing companies and defending a company against an SEC investigation or any government investigation is expensive, right? In terms of the resources that are used for the company, the cost of outside counsel and outside advisors, the cost of production, all of that is very expensive. And then the length of time that investigations can take. It used to be that an accounting fraud investigation would take about 19 months to, right, from start to finish. I don't know if the time is now decreased, but that's what it was, you know, in the early 2000s. And, you know, investigations take a long time. And so for that reason, I think companies are very skeptical about, well, why should I go to the SEC, self-report, you know, help them translate documents, bring in individuals for testimony when this thing could be going on for 4 years rather than 2 years after I've neatly handed them, right, the investigation in a bow. And I think that's where you find the skepticism in that the length of time, the cost, et cetera, the drain on the company takes a really long time. With that said, though, you know, with the Dodd-Frank Whistleblower Act, where individuals can receive up to 30% of the amount of the penalty when they come forth to the SEC with original information, that's new original information about wrongdoing. There's an incentive for more and more individuals, whether they work for the company, externally to the company, to go to the government agency and to report the wrongdoing. And if that's the case and the SEC finds out about corporate wrongdoing that way, then you're in, again, for a very expensive investigation, which drains resources and takes a length of time. And you're in a far worse position than you would have been if you did self-report.
And so I think slide 11 gives us a bit of a flavor of that, because here you will see that Anheuser-Busch had a lower disgorgement amount, which is really what makes the shareholders whole, right? That is paying back the amount that was gotten by illegal gains or ill-gotten gains. And the penalty is much higher, not only than the disgorgement amount, but then the penalty that SAP paid. So I think this gives us a graphic representation of what cooperation can get you. I actually have a good question from one of our viewers who wants to know when both the disgorgement and or the penalty is paid. Where does the money actually go?
So it depends on the type of case, because one of the missions that the SEC has is to make injured shareholders whole whenever possible. So in accounting fraud cases, for example, my group did a case an accounting fraud case against Weatherford relatively recently. They paid about $140 million in penalty, and there was an action against their auditors as well. That money is going into a fair fund that will be paid back to injured investors. So investors who held the stock during a period of time where the stock price was impacted by the financial fraud that was going on. And that's typically what we do with most types of cases: market manipulations, insider tradings. There'll be a fair fund to pay back the money to injured investors. FCPA cases are a little bit different because shareholders aren't actually harmed by the bribe scheme. They get the benefit, if you will. The company gets the benefit of the business. But generally, most types of cases, we're going to, wherever possible, pay it back to the injured shareholders.
On Fiona's points, I thought those were great points. And I asked her to go first because auditors do not give legal advice. This would be done in conjunction with counsel. So I would not say to my client, I think you should do this. I did mention before about there is some skepticism, and I've heard those conversations about that. You did bring up the whistleblower bounties. It is top of mind for many of my clients. They're scared to death that something will come up that they're not even made aware about, because they know that their employees have the affirmative obligation to report to them something that's happened, some integrity breakdown, but they're scared they're going to go elsewhere with it first, even though the code of conduct says you come internally. But it is top of mind for many of my clients. But again, as auditors, we just don't make that kind of legal advice. But I hear the conversations, but I don't chime in.
I think it is absolutely true that the whistleblower provisions in some ways for companies, I think, were game changers, because it did change the calculus on whether you self-report or not. I think it's not just that, it's also, there are many more ways that the SEC learns about wrongdoing, not just through the whistleblower program, but also because we have much more international cooperation than we used to. If you're going to make a restatement, for example, that's going to be clear that we're going to find out about it. I also want to make sure that we're making a distinction between self-reporting and cooperation, because you can choose not to self-report and you can still say, but if the SEC comes in, we're going to cooperate. What I think companies want to think about when they're making that decision, do I want to self-report or not? In some ways, it's a risk analysis, right? How risk ready or risk averse is the board? Do you sleep well at night knowing that you have this big thing out there that the government might or might not someday find out about? It may be informed, as Fiona said, by whether you have an internal whistleblower, because quite often if you have an internal whistleblower that's reported internally and they don't see things taken, that's probably the most common type of whistleblower that we see at the SEC. But then you also have the issue of, okay, let's say that you don't self-report, or you haven't made the decision to self-report or not because you're starting your investigation, you're just not ready to come in. And the government comes in because somehow we either get a whistleblower or there's some other way we find out about it. Then you have a decision, how much do I want to cooperate or not? Do I want to translate those documents or make the SEC go translate the documents? And to some extent then, it's really an assessment of how hard do you think the SEC is going to look, because we don't have unlimited resources. We definitely don't have unlimited staff, because we'll typically have 1 or 2 staff attorneys working on a case, but we are getting much better about using big data, about using analytics, about doing data analysis. When I started at the SEC, it was still boxes of documents. On a big accounting fraud case, you got 100 boxes of documents and you went through them page by page. Now it's all electronic. Our programs, like in the private sector, have data analytics that let us do particular searches for search terms, for patterns, for particular date ranges. We can do mapping and those types of things. We're also going to translate those documents. I mean, chances are, if it's a little case, maybe it's not going to be worth the resources, but if we think it's a big case, yes, we're going to hire the Chinese translators or the Spanish translators. It's just going to take us longer. And that means you're going to be under investigation for that much longer. I think to some extent, it depends on what the company sees as the end game. Because if you see at the end game that you don't think there's a problem, or you're going to want to fight it all the way through, you may be an incentive to just drag it out and fight it all the way through and hope that we don't get there. If you think there's a real problem, and I think for accounting fraud cases, if you've made the point that there's a restatement, to some extent, I would think a company just wants to figure out what went wrong so it can't go wrong again and get through that process as quickly as possible, because you've already made the determination that it's material misstatement.
So I'm going to move us along to slide 12. And Fiona, I want you to walk us through. Let's assume that there has been a situation in a company where there's suspected violation of the federal securities laws. And so walk us through, just in a very broad basis, the things that a company should do and consider and when, knowing that each case is individual, facts and circumstances will dictate how to do it.
Absolutely. So key to any decision to self-report is having the involvement and active engagement of the board, and the board taking steps to make sure that documents are preserved, that information that would be key to the SEC investigation is not destroyed in any way. So figuring out what the impact is to the company and bringing in the right advisors are also key. One of the things that I think a lot of companies trip over, and we've touched on, is how much information does the company have at the time when they're making this assessment, and when should we go in, right? Some people want, all of the information, right? They want to do all the interviews of witnesses. They want to collect all of the documents. They want to be sure that when they finally do speak to the SEC, that they have everything nice and neatly wrapped up in a bow. Well, it turns out that that is not always the best case. That's not the best case scenario. When I tend to work in matters, it's usually I have a sense of what's happened. I have a sense of who the key players are. I can speak to the SEC about what the potential violations are, and I can definitely speak to the SEC about what our roadmap is for the internal investigation that we will conduct. And then I can talk to the SEC about how often we're going to talk to them, what key documents we're going to provide to them, and explain what these documents means, who the players are, a chronology around the information and the matter at hand, so that the SEC, by the time I make the initial call and set up the meeting with the SEC, at the end of that, they have a real sense of what the investigation involves, who is leading the investigation, right? Which advisors are involved? Do we need a forensic accounting firm involved? And who's the forensic accounting firm? Who, as outside counsel, am I reporting to? So is it the audit committee? Is it the special litigation committee? So that they have a real sense of, okay, the company takes this seriously, the board takes this seriously, and we know what the action plan is. And it's particularly important to spell out what the action plan is, because the SEC may want input, right? Want input on witnesses, want input on where to look, because potentially by the time I walk in, a whistleblower may have already come in, and the SEC just hasn't issued the subpoena or the document request yet. But I'm here saying, okay, we know this matter, we have this matter, and here's how we're going to address it. And then being sure that you communicate with the SEC regularly about what you're finding, who you're talking to. The question always comes up around, do you waive the privilege? There's certain ways to give the SEC information without handing over the interview memo, for example, right? You can provide summaries, you can provide a download or a debriefing or oral debriefing, which doesn't get you all the way to, right, waiving the privilege. So these are all of the concerns and steps that people take in order to walk something into the SEC. I don't know if you have additional thoughts.
No, I was going to say, I think those are very important points, because honestly, what we hate is to see a company spend a year doing an internal investigation. They come in, it's all wrapped up in a bow, and they think they're done, and we look at it and we say, okay, well, what about this, 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 and this? And now you've talked to all of these witnesses, so they already know the story. They've already seen the key documents, so you've impacted our ability to do an investigation. In my job, I get a lot of self-reports. In fact, I got 2 this week, and in both cases, they were exactly at the stages that Fiona was talking about, which is they had not done the entire investigation. They had really just begun and just had enough to scope it and say, we know at a minimum we have issues. We know that this is not something that turns out, that we're not already seeing that we think we're going to have a problem. And I think the point that Fiona made is a very important one, that when you come in at that stage, you've already gone far way down the road towards establishing that sort of relationship of trust with your regulator that you want to have in order to get through the investigation as lightly as you can get through it, because I know that investigations are not fun from the other side. I mean, for us, they're our job, so it's more fun to sit on my side of the table, definitely. But I would strongly, strongly encourage companies that if you're going to come in, don't wait until the end, because then you're going to face a lot of questions. And if you decide that you don't want to self-report and you don't want to come in because you think it's a minor issue, that's okay too. You're not required. There's no law that says that you have to come in and report. You're not going to get credit, but fine. But make sure that the company, that management, that the outside auditors have thought through, what do I do if a year from now there's a whistleblower or the SEC comes in because they're looking at this particular issue in one of my competitors, and they start knocking on other doors and saying, hey, do you have this, who else has this issue? Am I comfortable that when I have that meeting with the SEC, I can walk through everything we did to investigate and everything we did to remediate, and I'm comfortable that they're going to say, okay, that sounds good, as opposed to, I just opened an investigation and now you're going to get dinged or hammered for not having come forward because now it's a year, 2 years, 3 years later, and witness memories are gone.
Right, that's a good point, because one of the things, as we talked about, companies struggle with, do we self-report? But as a good corporate citizen, you want to make sure you have the mechanism to right, investigate and look at issues as they arise. So an ethics hotline, a whistleblower hotline, call it what you want, a special investigation committee so that you have, right, internal audit involved, you have someone in the general counsel's office involved who can look at these issues. And if at the end of the day you decide not to self-report, because I actually believe that not everything should be self-reported to the government, you need to make sure that your file is one that is thorough enough so that when the government, or if the government ever comes knocking, you can turn to them and say, this is what we did and this is how we handled this matter. This is how we remediated, the steps that we took, these are the individuals that we fired, or the bonuses that we dinged, in your technical term. So you want to be a good corporate citizen, and you don't need to go to the government each time to self-report a matter. I know the preference is for self-report, but I actually believe that corporations, if they have the right internal controls, the right tone at the top, et cetera, that they can do the right thing without going to the government and self-reporting.
And I will not disagree and say that I think every little violation needs to be self-reported, but I would say that if it's a significant violation, I think a company is always better self-reporting and always better coming in.
So let's move on to slide 13. We've covered most of these issues, but there is one that I want to point to, which is the last one, the potential privilege waiver. We talked about that very briefly, but we've gotten a couple questions about that. And when would you waive legal privilege? Can you give any broad strokes, Fiona, again, knowing that it's very facts and circumstances?
I wouldn't give any broad strokes, actually. I just wouldn't. I think each situation is different. There are different types of waivers you can give, right? So you may want to, I don't think in any case you want to give a full outright waiver, that you want to very carefully craft a limited waiver if that is what you want to do. Because there are situations where the general counsel's office may be involved in the wrongdoing. And so there are memos or emails or legal advice which may be key to the investigation. It may be key to exonerating the company, or it may be key to actually proving culpability. And so in that case, you would want to consider waiver, but you would want a very limited waiver.
Okay, very good. So Tim, quick question to you. Have you ever had a situation where the report has come to you, so it hasn't gone to the SEC through the whistleblower hotline, it hasn't gone to the ethics hotline, but it's gone to the outside external auditor, and how do you deal with that if that situation would arise?
You inform management, plain and simple. It doesn't happen that often, but sometimes the auditor be notified concurrently with the board of directors, the audit committee, management of the company, but it doesn't happen terribly often. But our first step would be notify the company that we have this issue exists, and then will there be certain expectations of them?
That they would let the board know?
Well, they would let the board know, but they would still make a prompt and appropriate investigation or response, which would probably be an independent investigation. Measure the effects on financial statement amounts, ring fence it to make sure that they understood who knew what and when, identify the internal control breakdowns. Conditions had to exist to allow something to occur, so there has to be some sort of internal control breakdown. Remediate, you mentioned that earlier, personnel actions, repair of internal control deficiencies. And then the expectation would be that they would have frequent, transparent communication with the external auditor. Under no circumstances would we direct the investigation, but we certainly would want to be cooperative in the investigation, fully informed of it, and make sure that it meets our audit expectations, because at the end of the day, we have to sign an audit opinion.
I've seen it. I was just going to say that I have seen it come up in some cases where the auditor found out about it during the audit, while someone on the ground getting the information, a member of the audit team, is talking with someone in, for example, the financial department or the accounting department, and finds something. And I know that Tim was alluding to this. The external auditors have their own obligations under Section 10 Cap A of the Exchange Act to make sure that The management handles it. If management doesn't handle it, the board needs to handle it. If the board doesn't handle it appropriately, then the external auditor actually has an independent obligation to notify the SEC of the wrongdoing.
So, Cindy, one thing, just listening to this very complicated but important discussion between Fiona and Cara, one of the things that took me right back to the most stressful part of the process that I got involved in was constantly being concerned that there was a dialogue going on between the external counsel and the SEC about expanding, when we, the directors, saw no reason to do that, no need to do that, no reasonable grounds for believing that there was anything further that should be investigated. And we always had this nagging concern that there was a different motive on the table about expanding the legal work for everyone involved. And it's a real issue, I can tell you, for boards of directors. In the examples I talked about, the total external legal costs were the highest single cost of the entire process. And I think that whilst it's important to trust your external advisors, to rely on their expertise, I would urge all directors who find themselves in a position like this to retain their own wisdom, sense of judgment, ability to continue to direct the investigation, not to run it day by day, but they are the ones who should control the pace of it, the extent of it, and so on. If you get to a point in time where the SEC wants to take the investigation into a further direction, they'll do that anyway. But the cooperation, I think, doesn't mean you must do absolutely anything that your lawyers suggest. And I look back on the experiences I had, and I wish that there were times when, as the audit committee chair, as the chairman of the investigative committee, I wished I'd been a little firmer on that issue to protect the interests of the shareholders a little more aggressively. Easy to say in retrospect, pretty tough at the time.
And I think that's a perfect example of what I was talking about earlier, where there are points in the investigation where it may absolutely make sense for the chairman of the audit committee or the chairman of the special committee to come in and meet with the government so that you can hear directly from the SEC staff why we think the investigation needs to be expanded to a new country, to a new area, to for accounting fraud case, if it's revenue recognition in one particular division or business unit that we want to see it in elsewhere. You may disagree with it, but at least you're going to get that opportunity to hear directly from the regulator. And I would just encourage companies to keep that in mind, that generally the SEC is always willing to have company representatives there as well as outside counsel. It doesn't make sense, obviously, to have them there all the time, and that's a discussion to have with your outside counsel. But I think sometimes companies forget that they are the client, they can always come to the meeting.
And I think Leslie Caldwell of the DOJ gave companies some cover there as well earlier this year when she said that, during these investigations, particularly FCPA investigations, that you don't have to boil the ocean, right? So I think there is some validity definitely to containing an investigation. And I'll say, sticking up for outside counsel, we don't necessarily want to do an investigation for 5 years because, right, the relationship and the strain on the company, right, as a good outside counsel, you don't want to strain company resources to the point where they're unable to conduct their day-to-day business. So boiling the ocean is not necessarily the way to go.
I'm going to move us on to slide 14. I think we've covered most of slide 14, which is the risk of not self-reporting. But there is a question that we've gotten from our audience that I think goes to this slide, and that is, are there scenarios when it's too late to self-report?
Well, it's too late to self-report once the SEC is knocking at your door. Yes, you're not going to get any credit for that. But I think that the most credit you're going to get for self-reporting is if you come in at a point in time where there was really no likelihood that the SEC was going to find out about it. If you come in and you self-report and you tell us, oh, by the way, we understand that a reporter from the Wall Street Journal may be running an article on the front page of the newspaper tomorrow, you're going to get limited credit for self-reporting because guess what? We would have discovered it tomorrow morning when we opened up the Wall Street Journal. So I think it's also difficult, as we talked about, to really get a lot of credit for self-reporting if you're coming in a year 6 months, a year after you've basically done the investigation, tied it up with a bow and said, here, just rely on what we've done, because we're unlikely to be willing to rely on what the company's internal investigation has done. We may be very willing to let the company do an internal investigation and continue to report back to us as long as we have input into what's happening, and also as particularly in instances where it may be more difficult for us to do the investigation. For example, if it's in overseas in countries that are more difficult for us to get access to witnesses, but we want to have that dialogue. So also, from the company perspective, sometimes we find that companies have come in and they've done a wide-ranging thing that we would have said, you don't need to look there yet unless we think there's an issue. It's one thing, for example, if you have management in a particular foreign subsidiary that has a problem, and you have a particular problem, let's say, with hiring third-party agents, and you discover that there is a problem with your internal controls. You're just not really catching third parties. Okay, do you want to expand it to see where else may I have, since I have this hole? Yes. If you have a problem with management at a particular subsidiary, and you discover that the business sector at a higher level, or and not just at a country-specific level, is involved in that misconduct, should you look to see what other countries they might have been doing nefarious deeds in? Yes, absolutely. But do you need to go to the other side of the world? No, not unless you think there's a reason to.
So a question from the audience: does self-reporting always trigger an immediate SEC investigation?
No. I think people are surprised to find that out, but no. In fact, there are, we don't publicize the number of self-reports that we don't get in. We don't publicize the number of cases that we choose not to open, that we decline without taking action. But yes, there are certainly a pretty sizable number of self-reports where companies are coming in. Typically, it's companies that have good internal controls and good self-policing, so they're able to find problems while they're small and remediate them quickly. Those are most likely the cases where we're going to just say, all right, fine, finish your investigation, come in, give us a report. We just had this discussion with outside counsel on a case 2 weeks ago, and I said, we're done, no action, you handled it appropriately. So
but again,
it happens.
You guys don't publicize when you decline.
And we've had those discussions.
Right?
We've had this discussion, and see, that's the issue, right? We've had those discussions internally, and there's a back and forth. Because I will tell you that the companies that are in that situation do not want us to publicly identify that we declined. So it's really it's somewhat of a catch-22.
Right, but you also don't explicitly often say in the settlement agreement this much credit was given. Now, we saw the Anheuser-Busch versus SAP case where one could figure out a little bit maybe how much, because there was no penalty in the SAP case, but it's not often explicit.
So what I would say is that is absolutely true, that we are typically not in most of our settlement documents, we're not going to say we could have done a penalty of X, but you can see the penalty of Y. What I will say is it's a general rule of thumb: if there's a disgorgement amount, the penalty in a civil court action could be up to the amount of the penalty. It could be higher, because we can also do a per violation that could be higher, but that's an easy rule of thumb. You didn't even need to see SAP and the zero. You could just look at Anheuser-Busch and say their penalty is about the same as their disgorgement. Doesn't look like they're getting any credit for cooperation. You can also look at our documents, because if we're giving cooperation credit, we will have a discussion in our settlement terms of what the cooperation was. So you can look at that, and you can look at the resolution and see.
And we've gotten a couple of questions, but just to be clear, there still has to be the disgorgement about, because that is giving back the ill-gotten gains.
Yes, we will typically not, we won't waive disgorgement, because that's just putting a company back in the position where they should have been. So certainly in FCPA cases, you will generally see disgorgement, unless, for example, the company didn't get the business, in which case there may just be a penalty because they didn't make any money. For accounting fraud cases, there may be a benefit, there may not be a benefit to the company. For other types of cases, it's the same thing. Like with an insider trading case, even if you cooperate, you're going to have to pay back the profits that you earned.
So moving on to slide 15, again, we've covered a lot of the ground here, but this just gives us the types of information either that the company should gather before they go self-report, or that they should expect to have to turn over after they've come in to self-report.
Right. During various intervals in the communication with the SEC, you would provide some or all of those documents to the government.
And Kara, does it matter who comes in? Like if the head of the audit committee came in to self-report, or outside counsel, or the general counsel, do you give any credit based on who the actual reporting entity or individual is?
I mean, we typically, most often we'll see outside counsel. Sometimes we'll see in-house counsel. That's much more rare. It doesn't matter who self-reports. It does matter to us, as we've talked about before, who's doing the internal investigation. That can have a big impact on how much weight or credit we're going to give the internal investigation, because we are going to be paying attention to what the potential motives or ties are, or conflicts between, if it's long-term corporate counsel who was there representing the company at the time the conduct was occurring, I think it's harder for even the law firm to look at it with fresh eyes the way that a new firm will. So typically, best case scenario for us is that there's an independent group of the board who's not involved in the misconduct, who is overseeing an independent internal investigation by new outside counsel that wasn't involved, hasn't represented the company before, so that they can say that our client is the independent board members, our client is not management. And that's really where we see, I think, the tension.
And Rodney, is that how you structured yours?
Absolutely. I think it's critical. And I don't think the independent directors would be willing to expose themselves to having to work with people who they don't at that stage know whether they were part of the original problem as it arose. So moving to a truly independent investigative capability is absolutely the right thing to do. It may take a few weeks to get to that point, but it's the right way forward.
Well, and that's really the crux of it, right? As an independent director, with a responsibility here, you don't yet know who's implicated. You
don't know who's... And directors are likely to find themselves in a position in many investigations where they don't know whether the leaders of the firm, the management of the firm, are going to turn out to have been sufficiently responsible that they should not be entrusted with the continued leadership of the firm. You may know that on day one. And one of the things, going back to our earlier conversations, I do think that the board should take early action where it knows for certain who's culpable and who is actually responsible for an investigation. They've done enough work, and with the advice of independent counsel, they can say this individual or these individuals should not continue with their responsibilities inside the firm. You should let them go. I think that's urgent action. But the difficult part for any board of directors is you may be years through the process before you really know how deep that goes or how high that goes. And it's tough. And I recall that the final settlement negotiations that I was involved in with the SEC involved an agonizing judgment about whether to support continued investigation against senior management or to settle the whole thing for the firm. The trade-off between being loyal to the people that you have relied on to run the firm and you still think were doing it the right way, or whether you look after the interests of the shareholders and take a different judgment. It's very tough, and I hope not too many boards of directors find themselves in that position.
Well, let's move on to slide 16. And Tim, I do want to ask you to remind our audience, when the external auditor is providing their financial statement audit and their audit over internal controls over financial reporting, what is their responsibility if they suspect or see a potential violation of the securities laws?
Well, our approach would first be to determine whether or not an illegal act had occurred, what the effects were on financial statement amounts, the nature of remedial action. Some of the things that we would also think about would be intentionality on the part of individuals in the company. That makes a big difference, particularly when you're talking, it's a qualitative material issue, there was intentionality involved. Whether or not excessive pressure in the company led to the behavior, the benefits accrued either to the company or to individuals, whether it has been ring-fenced, that we understand who knew what and when. That's always a big problem when we're talking to an investigative team. How do we know that you've contained this? How do we know that another level of management hasn't been involved in this? After that, you would probably think about anybody who was functioning in a report, had responsibility for financial reporting. Were they involved? We would also, and I think it's probably the most important part, some consideration given to the integrity of management. Because if everything we do is based on the integrity management and the kinds of representations we get from individuals. But again, in that process I'd mentioned earlier, we would not direct an investigation. The idea is that we want to be a full and complete participant in some sense with respect to being notified about this, and to make sure that these activities that we're taking would meet our audit expectations. Because I think the conversation earlier was to notify the SEC early. It's the biggest disaster if you notify your auditor a week before you think he's going to sign off, and suddenly there's been an investigation, and then we look at the investigative steps and say, this is not going to work, because all those things they just pointed out, you didn't cover those things off, so it causes a big problem. So notify the auditor in a timely way.
I
go
would
ahead.
quickly say that I think the second worst case scenario for a company, other than getting a subpoena from the government, is when you need to tell your auditors that you found an issue, a potential illegal act, weeks before the financial statements are due to be filed, and you can't file your financial statements.
Yeah.
I think that is like the second worst case scenario
probably
for
neck
public
and neck
companies.
Right,
exactly.
Yeah.
So we're almost to the end of our time together, but I do want us to do something that I like to do at the end of every webcast, and that is to ask each one of you what your key takeaway is. So moving on to slide 17, if you had to leave our audience with one point to take away or to remember from our time together, what would that be? And Fiona, I'm going to just start with you.
Sure. So my key point is that the decision to self-report should involve, the board of directors being actively engaged. Management does need to be involved, of course, and that you need to hire experienced enforcement counsel who has a rapport and credibility with the staff, counsel that knows the right folks to call and what you need to do when you decide to self-report.
Rodney?
Directors need to recognize that an SEC investigation is almost certainly going to be stressful and time-consuming. But on balance, based on my experience, it's better to cooperate with the SEC than not.
Tim?
Well, I think Fiona put a really good fine point on it for me, and that is to notify your auditors as early as possible, maintain transparency, but keep the process going. Sometimes people come to us, we got an issue, and we'll get back to you in about 2 months. It really needs all along the process. You have to have the checkpoints, but I think Fiona did a great job pointing out it's a big deal if your auditor is not comfortable.
And Karen, I'm going to give you the last word.
Sure, and this is a point that we've talked about, but I think that during an SEC investigation, full and frank discussion and communication with the staff is really the best approach, because it's most likely to avoid misunderstandings down the road.
So that about wraps up our time. In closing, though, I do want to express my appreciation to our panel, Cara, Tim, Fiona, and Rodney. I also want to thank all of you who are watching for joining us and giving us your questions. And I think you will agree that the panel gave us very frank and open insights based on their experience. So we very much appreciate that. I would like all of you to take a moment. I'm going to ask you to please take a moment to complete the webcast survey. A link to the survey should have popped up in a separate window on your computer screen. We very much value your feedback. It helps us improve the webcast as we go forward. And for those of you who wish to obtain a copy of your CPE certificate, it will be ready immediately following the webcast. All you need to do is click on the CPE button at the bottom of your screen, and that should give you your certificate. If you don't have an opportunity to obtain your certificate at the close of the webcast, you can do so 24 hours after the webcast by logging back into the event and clicking the Get CPE icon button. Please note that you will not be able to respond to the attendance checks in the archives, as you must have fully participated during the live presentation to qualify for CPE. If you have any questions regarding the NACD credit, please contact the NACD directly. And any of your colleagues who were not able to join us today can view an archive of this webcast and prior collaboration webcasts. This one will be available on the CAQ and the Anti-Fraud Collaboration websites very shortly. And with that, I'm Cindy Fernelli of the Center for Audit Quality, wishing you all a good day.